you're my everything, yeah. My everything is you, Lord. Yeah. Ha-ha. Oh, 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 oh. Everybody say, ah. Oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, yeah, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uyamatingina. 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 Oh, uyamatingina.
Hello, lovely people, wonderful family out there. This is an opportunity for us to meet on the community and the law. Today is the 11th of March 2023. Now, we have entered March, which has been dubbed as Ghana Month. And we will be concentrating on some of the things that we do back in Ghana, the bits that you would want to know, where you need to visit, and of course, all the things that Ghanaians do that will benefit every Ghanaian living everywhere and people who are associated with the people of Ghana as well. Welcome to the community and the law. My name is Oreku Sifrimpan, and today I'm going to ask you the question, and I know there's going to be an answer from BWF Solicitors, our collaborators, partners, and sponsors who are bringing us resource to get our community and the law program going. And the question is, can I still apply for my pre-settled status after my first 6 months visa, even if my parents have separated? Now, apart from that, I know you have other legal and nationality questions that you want to put out to the lawyers from BWF Solicitors. So I am asking you, from left, right, back and front, everyone, let's get ready and get into it together, the community and the law. Hello. Once again, I would want to express my appreciation and my gratitude to all of you for being here and also making sure that we bring everybody around the, back in the day would have said the fire. So the old lady would bring us the folkloric stories of Nancy and everything. Now, today we are doing that on a modern platform, and we are here on the Community and the Law program, where we bring you all the questions, all the answers, and all the things that we need to clarify when it comes to the law. And I'm doing that courtesy of BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors are at 214 to 218 Tottenham High Road, Seven Sisters And they are so gracious to us that every Saturday afternoon they bring us the opportunity to be live on BW TV and BW Radio to look at some of the things that bother us during the week. And today, the question I am posing is quite simple and straightforward. You know, EU and its settlement scheme will never go away from us. People are still ask the question now, if I have had my first 6 months visa, can I still apply for my pre-settled status after that first 6 month visa, even if my parents have separated? Now, my parents have sponsored me, they brought me into the UK via the EU settlement scheme. Now, um, before 6 months, something has happened and there's a separation. The question is, can I still apply for my status in that situation? We'll be answering that question. And my friend, my brother, and learned friend, Lawyer Charles Asma, is here courtesy BWF Solicitors and is going to help us answer some of these questions. Apart from that, there are a few things, so to speak, that I will need to go through. Now, first of all, the month of February have come and gone. Now, February coming in, we had all the days to work. Um, BWF Solicitors appreciates hard work, and they have gotten two of the members of staff who have been voted the employees of the month. So we will acknowledge the two of them. Deborah Du and Annie Soa are our employees of the month, February 2023. Wonderful, beautiful ladies who help us go through everything we send to BWF Solicitors. And we want to appreciate them and, of course, honor them for being employees of the month. BWF Solicitors says Aiko to Deborah and Annie for being employees of the month. Now, next, I'm going to also mention that we're celebrating Ghana Month, which is the second announcement I'm bringing up. And Ghana Month says that everything Ghana is going to be celebrated this month, in the month of March 2023. So the national monuments, the places you need to visit, and all the other bits before the end of the month, we'll be highlighting some of them for you. But remember, when it's Ghana, it's our kente, our chocolate, and the cocoa, and all the warmth that we give you when you visit our country. And that same warmth is giving you when you visit BWF Solicitors, 214-218 Tottenham High Road. So visit them from Monday to Friday between 9:30 in the morning and 6 p.m. in the evening, and you will experience the love, the warmth from Ghana. It's the only law firm here in the UK that gives you Ghana chocolate when you visit them. So you go in there and make sure you help yourself with that as well. The next one, which is the third one I'm talking about, ladies and gentlemen, will be the ability to get your English language sorted when you are applying through or for the skilled worker route. KT Educational Consult is supporting with that. They help you to write your exams, prepare very well, and you are able to write and pass very well. So you can satisfy one of the conditions for skilled worker route visa and the care worker route and all the other bits that we have been highlighting. So you call them on 004475 966 20154, 004475 966 20154, and they'll help you go through your English language. Now, I have a question that somebody asked me, can you help me do this and that? Yes, you need to pass your English, and KT Educational Consult is definitely there to support you. So enroll with them, speak to them. The number again, 075 966 20154. Now to our nugget for the day. I would want to say and reiterate that every week, BWF Solicitors will bring us something that would help us understand what the law says and what the positions are. Now, today we are going to look at one particular one that says that we're talking about landlords, okay? All landlords in England are required by law to conduct a right to rent check before renting their property to a prospective adult tenant. Right to rent checks only applies to privately rented accommodation. So for instance, if a landlord is found to be renting to someone who does not have a right to rent, they may be liable for a civil penalty of up to £3,000 per tenant. If they did so knowingly, they may also be committing a criminal offense. Everyone who has lawful permissions to stay in the UK has a right to rent residential accommodation as their only or main home, even if it is a limited leave to stay. And that's quoted from the Immigration Act of 2014. This came out of a case of Secretary of State for the Home Department versus that is Joint Council for Welfare of Immigration, is a 2020 case. So please note that, and I will be getting the explanation of that. And with that, my brothers and sisters, ladies and gentlemen, let me welcome and introduce my resource person for the day, the afternoon, and the evening. And his name is Lawyer Charles Asma of BWF Solicitors. Uncle Charles, good afternoon.
Good afternoon, Radical.
Last week, I was on sabbatical.
You were.
As you lawyers will say, I was on sabbatical.
You were.
I had to go underneath for a bit. Man needed the rest. But thank you for, and also to my team, my right-hand woman, so to speak, for holding the fort. Thank you so much. And how's been the week? How's the week been?
Yes, the week remains promising and refreshing. We are hopeful that the coming week will even be better.
Right. Maybe today I'll just twist the tradition a bit. I'll allow you to say your good afternoons and welcome to people before I punch you with my question, because rent and the right to rent has been an issue people have been talking about.
Sure, yes. So a very good afternoon to you, wonderful viewers and listeners. Pleasure coming your way once more this wonderful Saturday afternoon. Today we have come your way with another interesting edition of the program, and I'm sure you and your peers will benefit so much from this. I want to say thank you once more and a very good afternoon. We are grateful to BWF Solicitors for the opportunity once again, and we are grateful to you too for making time once more to be with us. Stay put and enjoy.
Well, and with that wonderful welcome, let me also welcome all of you on the platform. I've seen that many of you have joined us on Facebook, many of you have joined us on YouTube. We are on all the other social media platforms. So what I would ask all of us to do, just a little exercise here. So pick up the link and share it with all the people in your network. So you pick up the link that you have and put it on your WhatsApp groups or send it to other people. And invite people to come in because the discussion is going to be very needful and, of course, very interesting. So those of you on there, I'll be mentioning names. But Emmanuel Santi Odame, thank you very much. Idrisu Sulemana, thank you. Pakwesi, you say you need our help. The Accra office is open. I'll be giving you the details later on, so don't worry at all. A skilled worker route application, you want details on that. Francis Poku, you are in Ghana. Yes, I'll be giving you further details on that. OT, thank you for joining us and all the other people that joined us. So when we activate the lines, I will be asking you to call us on 07399208 or you can send us a text via 07950422780. The details are there on the screen, or you can also call us via our landline 0208-123-1016. Now, lawyer, coming back to you, I read the nugget which talks about landlords and their responsibility and duty to check that whoever is coming to privately rent their accommodation should be qualified to do so. Now, when you say qualification, what are we talking about, and why do they have to do that?
Yeah, thank you very much. The nugget is clear on that. There is case law position and also statute position, and we're looking at the Immigration Act of 2014 and also relevant case law, which is the Joint Council for Welfare of Immigrants 2020 and the case of Secretary of State and R. What the law is saying is that if you are a landlord, especially private landlords, it's your duty to ensure that you are renting your home to someone who has the right to remain, first off, in the UK.
Okay.
Therefore, you are not attracting people who should not, or so to speak, you are not harboring immigrants, illegal immigrants.
Okay.
So that's the bit. So you can see the government is gradually pushing some responsibilities to the landlords, because they are the grassroots people. So if they decide not to harbor anybody, then those people will not have the joy to even stay, so to speak. So what the law and the policy is saying is that if a private landlord, before you give your room or house or home out, you have to check that the person has the right to remain in the UK, i.e., either the person is British citizen, has settled status, or limited leave to remain. Now, if the person has one of these three, then your first duty is met because you've checked and the person meets the first criterion.
Okay.
Now, if you didn't check and therefore you didn't know and therefore you give it out, then the law will punish you with a penalty of £3,000
Per person.
per person you give out to, so per tenant.
Okay.
So if you give to a family of, let's say, 5 or 2 or whatever, then times the number,
That's a
so to
lot.
speak. Now, so you can see that it's putting landlords, private landlords, on alert,
Okay.
so that they do the right thing by supporting the government to not harbor illegal immigrants.
Right.
Now, what if you knew and did it? So that's deliberate. Then that will attract even a criminal sort of a sanction. So in this case, you are not just going through civil penalty, but you
You're
may
treated
be
as a
taken
criminal.
through criminal liability.
Okay.
For-
Then let me then pose this question: that how do I verify the authenticity of the document or that bit of identity that a person has given me? So, for instance, somebody comes with a card that looks genuine. How do I prove that as a landlord?
So as you said, it looks genuine.
Yeah.
If it looks genuine and there's what we call reasonable care and attention. If you have exercised reasonable care and attention to assess that this looks like one of those, then, because you are not an expert, so you conclude on those bases.
That's right. Yeah.
However, if in doubt, you can call the Home Office to confirm that. So sometimes you can ask the person to go and get share code to verify the right to rent.
Okay.
So the person will get a share code for you, then you check to see that yes, they have the right to rent.
Right. So when the person brings in the share code, which I am assuming the Home Office would have issued to the prospective tenant, how do I check it? Where do I check it from?
So the share, so it's a system. So once you key in right to rent on an online portal,
Okay.
they will ask for the code. You put a code in, it will show that the person has leave to remain in the UK.
Leave to remain, maybe for the benefit of people who may not know how technical that is. For instance, I have come into the UK. I came in, I said I was going to visit a family member on my own for a period of 3 to 6 months. Do I qualify to rent any accommodation?
So what the law says is that you have limited leave to remain, or you have permanent leave to remain, or you are a citizen, so to speak.
Okay.
And limited leave to remain, generally we say is 2.5. Now, if you came as a visitor, already you would have told them where you'll be living. So they don't expect you to enter and rent a place because your intention was not to enter to rent to live. Your intention was to join family or friend for the period you'll be in the UK or be hosted by a hotel or accommodation provider. So all those things would have been verified at the time your visa is being considered. So you check, okay, you are visiting the UK, where will you be? Your visa application will tell them, either with friends, with family, or you'll be in a hotel. or Airbnb. So if you are coming as a visitor and you go to a landlord to say that I need a place to rent, the landlord has the right to say that no.
No, I won't give you.
And we don't expect a visitor to go looking for a place to rent because they came knowing that they know where to live or stay for the period.
Okay.
So I don't think it would be necessary for a visitor to even go renting.
Right. Well, I'm asking because somebody would pose the question. Well, I'm here for 3 months. I'm here for 6 months. I said I was going to live with a friend. Somebody's hosting me, a family member or thereabout, or even in a hotel. And I realized that I could rent somebody's apartment for a brief period of 3 months, which might be cheaper or not. But are you saying that the law does not allow a person like that in that category to rent a place?
The point I'm making is that per the provision of the law, the person who is visiting the UK would not presume to be stranded and therefore will have to go renting.
Okay.
The person would have already made provision for accommodation. And if you are visiting the UK, it is not a presumption that you go and look for a landlord. You know where you are going to live. And because you are a visitor, you come in to live with a family, a friend, or private arrangement, which will be hotel or guest house or whatever.
Okay.
Therefore, if the person now says that what I thought is not what is happening, then we'll say that is a critical moment that the situation itself will determine what you should do. That does not fit into the discussion.
Right.
Because we do not contemplate that will happen.
Okay.
So the law, I don't think, has made provision for that.
Yeah. Well, I was just trying to go out of the box.
So as and when it happens,
Right.
the person will be able to deal with it.
Okay.
But for the purposes of this general conversation, we're not going to preempt that and accommodate this in the discussion.
Okay. Now, the law states categorically that this is for private landlords. So it means that if you have to find yourself under any government scheme, these checks would have been made already.
So you see that with the government scheme, one of the requirements would be provide who are you and why are you here in the first place. So that would have been an automatic assessment.
Right.
But the private landlord, you are not going to request support. You are going to buy a service.
From there, okay.
And therefore, the seller of the accommodation, private seller, will have to inquire from the private buyer whether the buyer has the basis in law to buy the service.
Okay.
But with the government agencies, already the government has duty under the law to fulfill this. And therefore, before you go, and you can't even go to the council for accommodation unless you have the right to be there, to go to them.
Obviously,
so you won't even go to them at all. But what we are saying is that if you go to the government and it doesn't work out, you go to private. Most people go to the private. And if you go to the private person, remember that the private person has a duty, just like the government agency or councils that has a duty to check. You also have a duty to check, and therefore, they are required by law to do that. However, in attempt to do that, they ought to ensure that they do not knowingly or unknowingly discriminate against the person who is seeking to rent.
Okay. Now, finally on this one, I want to find out, previously you've made us know that now the responsibility of checking whether people are lawfully supposed to be in here is pushed on banks, landlords and all that. If I have a share code, can I use the same share code to check whether I can open a bank account and use the same to check whether I can rent a place to live?
So usually when you are requesting for the share code, the system will ask you what the purpose is. So you would have specified the purpose for requesting the code.
Right.
And the system will generate to meet that purpose. So if the purpose is for employment, it gives you a code that will meet that purpose. If it's for accommodation or rental, it will do so. If it's for banking, whatever, it will do so. And therefore, you have to tick the right box when you are requesting the share code and you are asked, what do you need the share code for? Once you tick that, the system will generate for that specific purpose.
Well, I said it was the last one, but something just come up and I need to follow up on that. If I live in an accommodation, I generate a share code, that is used to verify my status. I lived there for a year, 2 years, and I would have to move. If I'm moving into another accommodation, do I have to generate another share code, or the one that I generate at the start of the whole process is enough to move me on forever?
So usually share codes expire within 6 months.
Okay.
So even if it is the same landlord and the landlord is renewing your tenancy after 6 months,
You have to generate a
landlord
new
can still ask you to get a new share code, because at that period your leave might have expired
Okay.
potentially. So code lasts for 6 months and you have to get a new one. And as you said, the fact pattern provided or presented suggests that 2 years is long enough to get a new share code.
Okay. Right.
But it's not something you have to pay for. So anytime you can just go get a new one, because it's an online system that generates.
So okay. So if the 6 month has not passed and I generate another one, it won't give me the same one. It'll give me a separate one, but it will still be linked to me and my records.
Yes. So if you get a new one, it doesn't really matter. But I don't see why you have to go for a new one if the old one suffices.
I'm trying to test the
Yeah,
system.
yeah, you are right. Yeah. So if you can't, for example, you've got your share code, you can't find it.
Yeah,
You got it today. Tomorrow you can't find it.
that's right.
Go get a new one. And therefore, yes, you can get as much as you want.
Oh, okay. All right. Ladies and gentlemen, that's the explanation. Lawyers made it so very clear that all landlords in England are required by law to conduct a right to rent check before renting their property to a prospective adult tenant. Right to rent checks only applies to privately rented accommodation. So if a landlord is found to be renting to someone who does not have a right to rent, they may be liable for a civil penalty of up to £3,000 per tenant. If they do so knowingly, they may also be committing a criminal offense, and that's quoted from the Immigration Act of 2014. And it says that everyone who has lawful permission to stay in the UK has a right to rent residential accommodation as their only or main home, even if it is a limited leave to stay. But before you do that, please generate your share code, share it with your prospective landlord, so you will stay on the safe side of the law. He or she will also stay on the safe side of the law. If you want to read further, you can go into the Immigration Act of 2014, and that will outline that for you. We live on BW TV, live on BW Radio, and the program is The Community and the Law. The question we're posing this afternoon is, can I still apply for my pre-settled status after my first 6 months visa, even if my parents have separated? Now, if you are picking these ones, you realize that we have pre-settled status, your 6 months or first 6 months, then parents having separated. These three basic areas, obviously, we'll be putting to a lawyer to help us do that. But before that, let's say thank you to BWF Solicitors for supporting us all throughout the time that we've been bringing you The Community and the Law. The Community and the Law brings you every discussion when it comes to the law here in the UK. And BWF Solicitors, what we want to say is we salute. That's your message.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, we're back, and thank you for sticking around. Let's see, Nana24, thank you very much for coming in. You say hello. Yes, we do say hello as well. Nanaji, my class prefect, thank you so much. You showed me so much love the other day. I appreciate you. Ejiwa and Najima, good evening, everyone. Good evening, Ejiwa. How are you? I'd ask. Ademununkum is online. Thank you very much. Good afternoon, everyone. You say so. We have Sandra Fraser. Yes, Sandy, thank you. Good afternoon to you as well. I know, yes, she's done her thing. She's put all the details there, bus numbers, telephone numbers, where you can locate BWF solicitors and the rest of it. Join us on the platform. Sandra is there. She says, please contact our specialist immigration solicitors for further assistance. So what you don't get on this platform, you visit BWF Solicitors 214-218 Tottenham High Road, and you will have the support you need. Thomas Ohineba Kwamboache, greetings to lawyer Charles Asma. Yes, Kwame, lawyer's here, and he's nodded, so definitely everything's fine. Chiwo, you are here. Eric Kwamnasanti, you're here. Chiwo says hello. Okay. Those of you on Facebook, yes, we picked all your messages. Those of you on YouTube, we picked your messages as well. So let's keep going. I'm going to ask the question again, and straight we'll go into the discussion. Can I still apply for my pre-settled status after my first 6 months visa, even though my parents have separated? Lawyer, can I do that?
Thank you very much. This conversation is necessary in one breath, in that people make applications through their parents as key sponsors, i.e. the step parent or the biological parent, especially the step parent. And if at the time they have obtained the leave and entered the UK, there is separation, or the marriage is no longer as it was at the time of making the visa application, then becomes a bit challenging, making the transition from 6 months to enter and pre-settled 5 years to stay on.
Okay.
Because you still have to show that your sponsor is supporting you to make the application. And if it's a case of meeting dependency, you still have to show that your sponsor is still supporting you to meet your living needs because you are dependent on them.
Okay. So in a situation where, let me get this clarification. When we say pre-settled status, we have looked at that before, but for purposes of our discussion, when we say somebody has pre-settled status, then it means that the person doesn't have indefinite leave to remain. Is that correct?
Yes.
And what puts any person in that category?
Okay, so we know indefinite leave to remain. The synonym for indefinite leave to remain is settled status.
Okay.
So under the EU provision, they use the term settled status to mean indefinite leave to remain.
Okay.
So when someone says, I have settled status, it means they have permanent stay, indefinite. If the person doesn't have indefinite, then they have limited leave to remain, which is what we know. Either the person has 2.5 or this or that. Leave to remain limited, because it will expire and they have to renew. Now, the other version under EU law for limited leave to remain is the pre-settled. And the prefix is clear. You haven't settled yet, so pre-settled.
Okay.
So you haven't had indefinite leave to remain. Therefore, pre-settled means limited leave to remain. Settled means indefinite leave to remain.
Now, in this conversation, In our questioning, we said, after my first 6 months visa, where does that come in?
So the reason here is this. The question need not to be ambiguous. Because if the question doesn't specify that we are looking at someone who has obtained a visa, entry clearance from abroad, and it been given 6 months, because usually it's 6 months, and entered, and we just simply said that, can I still make my pre-settled application? Somebody would think that we are referring to someone from abroad within the UK, a EU, who wants to come and live in the UK and wants to do pre-settled. That's not the conversation.
Okay.
Or somebody who is holding EU passport or EU citizenship and living in the UK and entered after 2020 might think that this applies to them. No. We are referring to people who were in abroad, made application to enter via their EU family members in the UK, and had the visa granted and been issued 6-month visa. Once they enter, they have to now do the they have to now do the EU settlement scheme application.
Okay.
So at the time they are doing the EU settlement scheme application, they will ask simple question. They will be asked a simple question. Have you been in the UK for 5 or more than 5 years?
Okay.
If you say 5 years or less than 5 years, that means you fall under the pre-settled category. Okay. If you say more than 5 years or 5+, then you fall within the settled status category. But you know that somebody who has just arrived with 6 months can never fall under the 5 or plus, and therefore the person will say, yes, I've been in the UK for less than 5 years, and automatically will trigger pre-settled. However, there are some exceptions.
Okay.
The exception is this. If the person is a child under 21,
okay,
or just 21, because the law says over or under 21. So what about the ones who are 21?
Hovering around 21.
Yeah, so if you are under 21 or just 21, we assume that you are a child. And therefore, if you are making your application upon entry for your pre-settled status, the question will be, do you want your sponsor's status? If you say yes, if your sponsor has settled status, you get settled status.
Right.
If you say no, then you'll be given pre-settled because you don't want what your sponsor has. So that is something we want to put across, that if you are a child...
So it is something that whoever is making the application would have to, is a question you have to answer.
Yeah, it's a question.
You have to answer.
Yes, well, it's a question, so yes or no. If you say yes, then obviously they will not treat you as, so you'll not be placed under 5 years or more than 5 years category. Automatically you are a child and therefore you go with your sponsor. Okay. So if your sponsor has settled, you get settled. That's why you hear that someone who would have made an application, a person said, my child has been granted settled status, even though they arrived yesterday, because they chose what their mother, father, or the sponsor holds. So if the sponsor holds pre-settled, then you get pre-settled. If the sponsor holds settled, you get settled. That is only for children.
Okay.
If an adult, 21, over 21, then that question will not apply to you. They won't ask you that question because the age has triggered that, and therefore you move on to answer whether you've been here 5 or you've been here more than 5.
Okay. So in a situation where I come under sponsorship, and that sponsorship is a union between, say, my mom and my stepdad, or 2 parents. When I come in, which of them would I go under? My father may be having indefinite. My mother may be having a limited amount of time to stay in there. Who would I go under? Do I have the chance to choose?
You cannot choose. You have a sponsor, and therefore upon entry, the sponsor will not change.
Okay.
So if the application was sponsored by A, once you enter the UK, A will sponsor you to renew the 6 months to transit into pre-settled status
Okay.
application.
Right.
So when you are making your application, you'll be asked the details of the person sponsoring you and the relationship. You declare all that. And that's what they will ask you. Do you want that of your sponsor? The sponsor would have also done the same thing, the EU settlement, and therefore their details will be in the system. So when you are making the application, just as before you came, this time you'll be asked, has the person done it also? I'm sure you say yes. Then the question will be, what is their long number? 34 number. You put that also in there. There are instances where you may not be sure of what their number is for whatever reason. If you don't put it there, obviously you have to put something there. So let's assume that you put it there and you get it wrong. The system itself will do the search.
Okay.
Because if the person has done it, they will pick it up.
Pick it up.
So once they pick it up, then they know what the person has. Then they make your application, they make decision of your application based on that. If they don't pick that up, the presumption might be that the person hasn't done it. And if the person hasn't done it, they will come back for you to confirm, or they will just conclude that the person hasn't done it. And if the person hasn't done it, it's quite unusual, because for the person to enter the UK, we assume that the sponsor would have provided evidence that they have done it. But for whatever reason, if now the system is saying the person hasn't done it, we take it as it is. And therefore, the conclusion will be that you don't have a relevant person to sponsor you. Because a relevant EU national is somebody who has also done the EU settlement scheme to remain. But then we go into the exceptions with the case law that came up, wherein the learned judge said that somebody from EU who has decided to live in the UK has automatic expectation that they will remain in the UK, whether they've done the EUSS or not. And mind you, EUSS is a provision for people who want to remain to do it. If I want to remain, but I choose not to do it, does it mean that I'm not exercising the treaty right? So you can see that the learned judge was thinking along those lines that somebody who is in the UK with the intention to settle should not be precluded from settling, whether they've done the EUSS or they didn't. Just like the COVID, that's the simple analogy. If somebody decided to live without doing the COVID test, are we saying the person doesn't qualify to live? It's a matter of choice. It doesn't change the fact that they are still a human being. So you can see that people have not done the COVID test, but they are living. There might be some restrictions somewhere. However, the law, if we relate it back to the EUSS, what the learned judge is saying is that if they chose not to do the vaccine test, it doesn't change anything because they chose to live. And therefore, if those people from the EU who have not done the EUSS application, and therefore they are still here, you can say they are illegal, but the law says they are not illegal after all. Because choosing not to do the EUSS or enter into the EUS scheme doesn't change your treaty right. If we extend the conversation along those lines, then somebody would then argue strongly that then it doesn't really matter whether my sponsor has it or not, provided my sponsor was able to prove to bring me here, and now cannot prove that they have done it or not.
So by extension, we're saying that whether the parents are together or not does not matter because they brought me in.
So what we are saying is that the parents, the sponsor must be there to sponsor you.
Okay.
But where, for example, they say that the sponsor, there are 2 points here. The sponsor, for example, doesn't have the EUSS evidence. And so they could not have sponsored you, and so they can't sponsor you now. If we can establish that a person was living in the UK at the time and exercising EU treaty right before the withdrawal agreement came for them to do the EUSS scheme or enter the scheme, they were exercising their treaty right. Then whether they enter into the scheme or not, it doesn't change their position of their treaty right. So if the treaty right position hasn't changed, and the person hasn't got the EUSS evidence, are we saying that the person hasn't got EUSS evidence and therefore they are not relevant person and therefore they cannot
can't
sponsor you? The law, as we know, the case law, the recent case, the learned judge is saying that with that expectation, whether or not they have EU settled status application done or not, they can remain in the UK. That's one point.
Okay.
The second point is this sponsor still a family member? Because the person must be a family member. So if the familial position or family membership position has changed, how do we deal with that?
Okay. So then, technically, let me ask: if we say the familial position has changed, does separation come into play in the definition? Divorce, ultimate, does it come into play in this definition?
So the point is this: once there's separation, the law sees separation not as divorce. It's a prelude to potential divorce, but it's also opportunity for, there might be room for improvement so that it doesn't get to that point. But where there's physical separation, for example, where the sponsor, the original family member, or the relevant family member, who is the EU person sponsoring the applicant, is no longer in the picture, and there's no way you can find them, then you have to show that the relationship is broken so that you can retain the right you had.
Okay.
And how do you prove that the relationship is broken? Divorce. Because in this case, you said the person is your parent. Married to, by way of marriage to your other parent. So if that relationship is broken, then it's difficult to conclude that the person is still your parent.
Right.
But once it's broken and you can prove that it's broken by way of divorce certificate, then the argument will be that if the relationship is broken, we cannot punish the applicant. So the applicant can retain the right they had before under retention of right provisions. So there are instances where, for example, at the time of application, it becomes contentious as to whether the family member sponsoring the application has the right to sponsor.
Right.
Because there's separation, for example. But the argument will be that separation is not divorce. And therefore, regardless of the level of separation, there is relationship because the marriage is still subsisting.
Oh, wow.
It's weak, but it's not broken, is it? and therefore, your argument will be that, yes, this is happening, but there is still relationship. Because the only thing that severs the relationship is divorce.
Divorce, yeah.
And therefore, insofar as there is no divorce or there's no initiation of divorce proceedings, then we assume that relationship is there. It's weak, but that's life. So you cannot use it against the applicant. So if you argue along those lines in court, you win. Because the position will be that there's no divorce.
Does it always have to be in court, or you could state that as part of an administrative review, maybe?
You can state that as part of an administrative review, but it makes your case stronger if you're arguing before an independent arbiter in court.
Okay.
Because administrative review is still before the opponent who is recalcitrant to listen to you. So if the hostile opponent, the Secretary of State or the case worker, is saying no, and you still go to them to argue that, yes, you should say yes, or agree with me, they can still turn around and say, well, the evidence is still weak. But if you go to an independent arbiter in court who is neutral, then they hear your story, they hear what you, and the circumstance, then they conclude that, yes, this is the case. However, the law says so it cannot punish the applicant. So let's assume that the person has been able to enter with 6 months based on this argument.
That's right.
That there's separation but no divorce.
No divorce, yeah.
They've entered, and upon entry, you have to do your pre-settled status application, the transition. Your story hasn't ended. You still have to prove what you proved before. So if you had to prove dependency, you have to prove dependency again. If you had to prove relationship, you have to prove relationship again. Whatever you did to enter, you have to do it again.
Right.
So even if you manage to get through by way of argument in court, now they are more or less getting you again.
Because you still have to prove all those things.
So back to the point where you still have to show. And the question here is, at this point, what do I do if they have separated? So if they have separated,
Right.
and here we're looking at separation where it is impossible for the sponsor to support your application.
Yeah.
Then you have to potentially rely on your retention right status. And your retention of right status will be triggered by divorce, either divorce proceedings or divorce absolute.
But there's a situation, it's just separation. Nothing has been initiated. What do you
So there's no separation, nothing has been initiated. You can then push the argument to say that, right, let's hold it here. They have separated, but again, there is no divorce. And therefore, my right should be upheld as before. That take it that the person is still my family member, is still my sponsor. If you have all their evidence, you just provide the evidence, because this is not a court case where you need the person in court to say yes or no. It's evidential. So you provide what they have to make them qualified person or relevant person.
This is in a litigant relationship. One party is so aggrieved and bitter that for reason of showing that I have my right, I have the power, I'm not going to give you any evidence, any document to do that. In that situation, would the initial set of documents you use to enter suffice for you to prove that?
It's the same document you used to make the first application. The evidence that your EU sponsor has entered into the EU scheme, a settlement scheme, is still the same evidence.
Okay.
Either they are pre-status
Or settled
or settled status. You have the evidence, you have their status number, and that's what you
So the
will
3434
ask, the 3434. That's what they will ask you to enter, and that's what they will use to check whether it's true that they have. It might be the case that because of separation, either you had it and lost it, and so you cannot remember at the time of doing the second application upon entry. If you can't remember the 3434 of your sponsor, and because of separation, you cannot get it from them, as you said, they are hostile, they are unyielding and unwilling to assist, then you quote the number as you know it to be.
Okay.
If I know that the 3434 number is 3434 blah, 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 I will quote it as it is. That is where the caseworker will take the responsibility up to check whether this name has entered into the system.
Right.
If that name is in the system, they will know the right number and continue the process thereon.
Okay.
Now, we are looking at, as you said, somebody who is hostile, unyielding, and unwilling to help.
Right.
However, the person who is aggrieved, married to the other parent of this applicant, the other parent is still there. The other one, the main one that sponsored the application, may be at large. But the argument will be that, yes, the parent who is here has his or her leave based on this other parent who is at large and not willing to help. So we know that the parent, be it father, mother, has his or her pre-settled status or settled status. How did he or she get it? Potentially upon the other person, isn't it?
Okay.
Now, the other person is not willing to come in to help. So the argument is that if this parent is here, still looking for the other partner to come home, can the applicant rely on this parent who is here and got his or her leave through the other parent who is at large? If we extend that argument, then possibility will be that when they are seeking dependency confirmation, your argument will be that I depend on my parent, i.e. the one at large and the one here. Of course, if the one at large were to be home, I would have depended on both of them. But largely, the one here is the one who would have provided for everything anyway. And therefore, the one here is able to show that I depend on him together with the other one at large.
Right.
So it's a matter of argument, you can see. It's a matter of argument.
That's when I posed why I posed the earlier question that where do you go to make the argument? Can you make it on paper and leave it for them to administratively review, or you'd have to push for an independent arbiter or judge to look at that?
But before you go before a judge, then application would have been refused, and you are going for appeal.
An appeal.
That's one bit. If you feel that these are the key aspects, then the application, this could be also expressed. But again, you don't also want to preempt that. You don't want to put your challenges or difficulty before the caseworker so that it will be obvious that the caseworker should look for faults. So you leave the caseworker and, for if any, find the fault themselves.
Right.
So you make your application, put in everything you need to put in. Where you can't find certain information, you put the information as you know it to be. As I said, the case worker will check the system to know what the right information is. But where they can't find and they can't conclude that they have, and therefore they could have sponsored you, then the argument will be that if they don't have, how could they sponsor you?
Then you have to go to every length to prove it.
Then at this point, so you can then put in, if they give you opportunity to explain, you can put in argument in the form of a letter to them that this, and that, and therefore it should be as it is.
Okay.
If they don't, then they will refuse it.
Okay. Well, it's not the end of the world. The question we have asked, and the lawyer has succinctly addressed that and gone into some technical details, is that can you apply for your pre-settled after the first 6 months, even if your parents have separated, even if divorced? That's even easier because then you can have a certificate to that. If they have separated, there are steps you can take to do that, and that's what he has graciously and carefully explained for us. So if you have any text, you have any comment, you have any issue and question, the number to use is 07399 208 or 020812311016. You can send a text, audio text, or a written text to 07950 422780. I have one from Naomi. I'll be looking at that. George has sent us an audio. We have a few on the platform that we will be picking up. Oboy says, I'm from Belgium and I want to come to live in the UK. Can I still come, or is late to do that now, please? Oboy, I know your question has popped up because we're talking about EU settlement scheme and the rest of it. But then I'll throw it to lawyer straight away and ask, can Oboy Kwejo come and live in the UK?
I'll take the last part of his question. It's late to do so now. And the reason is that...
Is it late to do so under the EU settlement scheme or what?
This person is...
he lives in Belgium.
Yeah, so I suppose it's a EU national.
Okay.
And he wants to come and live in the UK. He's heard that it's late. He wants to know whether it is true that it is late. And I'm saying, yes, it is true that it is late. And the reason is that if you wanted to be in the UK under the treaty arrangement, you needed to have been in the UK by the 31st of December 2020. We are in 2023 and therefore too late.
Okay. But can it do it at all under any other arrangement or scheme?
Of course. Everybody in the world is allowed to enter into any arrangement or scheme that the UK government offers to the world. The person can come in as a student. The person can come in as a spouse of an EU national already living in the UK. The person can come in, of course, I don't know the age, but even if it's a child, can still, as a dependent of somebody living in the UK, can prove dependency and all that. Person can come in under the skilled worker program that the government has introduced, and so many other program. So if the person, for example, has found a job in the UK and the company is willing to sponsor them to have working visa, they can come into the UK and live. But the question was
Can I come?
targeted.
Is it too late?
The question was targeted, and the target was UU
Okay.
provision.
Well,
so he can't come in
One
under UU
very
provision.
interesting answer somebody gave him on the platform is Eric Komlasante says, "Come, yes, you can come. You can come, and you're most welcome, but it has to be under a different scheme, as lawyer has rightfully explained." The next one, Rebecca Mwako, thank you very much. Wishing me a belated happy birthday. Thank you very much. Umpini Adam, you're on board. Good evening. There's one that says, that was put on our text platform. It says, good evening, everyone. I am on 2.5 year, 10-year route. I think 2.5 is 2.5 years. So we can say that's easily. 2.5 10-year route, and I'll get 10 years next year. What will be the requirements for indefinite leave to remain?
Right. So I will offer an opinion on this as required under the law. My opinion is that if you are going for indefinite leave to remain, you have to prove that you obviously are working. You meet the financial thresholds. If you were sponsored by your partner, then you still have to show that the support is still there. You have to show the English language and life in the UK evidence. You have to show your accommodation and all that. If you cannot meet the life in the UK and English language evidence, you have to show that you can be exempted from that by way of medical report and assessment.
Okay. All right. So thank you very much. Thank you for...
And of course, you pay the fee.
Oboy Kojo is saying thank you very much for answering him. Oboy, yes, that's what we do here. And we want to say thank you to BWF Solicitors for supporting this program and, of course, allowing one of their very own to come in here to give us this wonderful legal education. Now, as a case says, please, lawyer, minors, I have pre-settled status. Can I invite my sister for a visit? My mother is working part-time and on universal credit. Can she invite my auntie? I'm 21 and working full-time. Then the question is, can I?
So there are 3 questions.
Yeah.
So let's take them in turns.
Okay.
The first one is, I have pre-settled. Can I invite somebody to visit me? As we have already alluded to, pre-settled is akin to limited leave to remain, or 2.5.
Right.
And therefore, as far as the person is legally resident, they can invite somebody to visit them, provided the visitor can meet the returnability test to show that when they come, they will return. That's the first point. The second point is that my mother, working part-time, universal credit, can she invite my auntie? The same principle. As long as your mother is in the UK legally, she can invite your aunt. As long as your mother can show the fact that she's on universal credit doesn't mean that she cannot support herself and the sponsor, the person coming. And even the responsibility is on the person coming to prove how they are going to survive. So if the person coming can prove that I'm able to survive, then it doesn't really matter whether the person hosting is able or not. But the reason why we expect the host to provide is that we don't want the person to become a burden on the host, and that burden extends to the state. That's why it suffices for the host to show. But if the host is able to show that they are able to meet the maintenance and the person coming's maintenance based on case law calculations, then again, the onus is on the aunt to prove that she will return after the visit. The third one, I'm 21, working full-time. Please, can I invite? Working full-time, we are not looking at how much you are making, so I want to believe that full-time means earning enough. I want to believe that you are 21 and therefore you have leave legally to remain in the UK. If that is the case, just like the first and the second answers, you can, but the person coming should show that they will return after the period of visit.
Okay. Your text, I will pick up on 07950422780. Your calls will come through to 0208 123 1016 or 073 208468. I've, I've got Emmanuel Nimaku watching with us. Lily Soa, thank you for watching. Ademununkum, yes, I mentioned you already. Osekwejo, we've answered your question. Sylvia Mensa, Frank Bonsu. Kevin Asamoah says, good afternoon, Reku, and lawyer Sir Charles Asma. Okay, now let's go to pick up this voice note, which I have on here. Then let's play. So, ladies and gentlemen, the voice note.
Hello, lawyers Nambacho. Good evening. Mechiaone, Mr. Framponi and Ray. My apply for settled status application that's a war system at the moment. Na me oba odi be 6 months. Na me pese me de ne ka application ho. Na me apply for also settled status emano. Na me try say me application no edru baby ana mo say me register a identity check for the baby. Now, identity check na more request either passport or biometric residence card. But me bano is just 6 months. Only passport, only biometric residence card. Your one in the birth certificate. Inti number say me who say about my 3 options. But use the EU exit ID document check app. And I'll book an appointment to scan my identity document in person. And I'll enter my document details online and send my identity document by post. Pacho, among these 3, which option should I use? And I say I was me use a different way. Now me apply, now me link about foreign application to mine to make me application and that's it.
Okay, go ahead.
All right, I think the focus is on the application of the child. You can see that this is somebody, so I'm looking about the child. This is a child who is making an application through the parent. When you are making a visa application, you must prove that you have a passport. You add your passport.
Okay.
So if you don't have a passport, they are saying that how do you make your application? Because you need your passport to be able to proceed. And the passport, you either authenticate it through the ID checking system or you post it to them. So those are the options. So the options are set in stone. There's no other option. I will propose that if the person doesn't want to get a passport for the child for this application, he should proceed with his own application. Once he's finished with his settled status, as long as the child is still a child, he can then rely on other provisions of the law to see how he can now register his child based on himself now that he has become settled and he has gotten settled after the birth of his child.
Okay. Well, one from Ade Mununkum says that, so if I understand correctly, what lawyer is saying that if you are an EU person, you can visit the UK, but you cannot stay and work.
I don't know whether we discussed that, but let me put that. The question that came was that the Belgian person,
Yeah, he
wanted to come to the UK.
Yeah.
And I concluded that an EU national who is late to enter but wants to know whether it is still late or okay. And we concluded that the deadline was 2020 December, and therefore, per the provision of the law, is late to come in under treaty right.
Okay.
However, you can come in for other reasons, to visit and go back. But this person, I suppose, wanted to come and live, because he said to live. So if you wanted to come and live, the visit option wouldn't be okay for you. So I didn't even mention that option. That means the person had to go through other means, coming as a dependent of a EU national already settled in the UK or in the UK, or through the work permit provisions or routes. So, or coming as a student. But of course, if the person is EU national and wants to come into the UK to visit, they can come in, because the law allows EU nationals to enter the UK limited period and go back.
Okay. So does it also mean that if somebody um, is a EU national from a different country and want to come and live here after the deadline and everything, the person would have to apply like any other person from any other part of the world?
That is the perfect conclusion. At this stage, if you are EU national entering the UK, you are just like anybody. The only exception would be that you can visit and go, but you can't come and live as before.
Okay.
So, and the same applies to UK nationals going to EU countries. The
Okay.
same.
Okay.
You don't need visa to enter a EU country, but you need permission to live there.
Okay.
It's changed.
Well, still on Oboy. I think the name is Oboy Kojo. Okay, still on Oboy Kojo. Can he, for instance, apply through, say, the care worker route if he's found a sponsor, somebody who can give him certificate of sponsorship to come in? Would the conditions be the same as any other person coming from, say, any African country?
So the person in Belgium.
Belgium, yeah.
So remember we said that the person is outside the UK. So this is someone abroad, and abroad could be any other country. So the person is in Belgium, yes. If the person finds an employer sponsoring them, they do it like any other person would do from any part of the world.
Okay. 0739920846, 020812310016, text 07950422780. Let's pick some of the comments from the platform. Lily Soa, good evening. You're watching from Reading. Okay, thank you very much, Lily. Thank you for your support. Thank you very much. It's a family question. I want to say a very big thank you to you, Pa. Okay, Seke, thank you for staying and also enjoying the program. Another one here, thank you for answering me on Boykojo. Yes, we have really dealt into your question and has followed up with others as well. Good afternoon, Ureku and Lawyer Charles. That's one. This from Kevin Asamoah. So let's see what you have. 0739920846, 0795042278. That's for text messages and WhatsApp and all the other bits. Another question here, Laura, is if, for instance, the Home Office asks me to bring further evidence to support any application, for instance, and I am not able to get that evidence, but then I go in to make a first application based on a different situation. Would they refer to the previous application and kind of punish me on that? Maybe accuse me of not being transparent enough or misrepresenting facts?
If you say to make it under different means or...
So for instance, if I applied as a visitor and they requested that I proved certain things, this returnability test and the rest of it, but then later on apply as a dependent of an EU national who qualifies to give me a pre-settled status.
Oh, so while still abroad?
Yes.
I mean, the beauty of a visa application is that your situations can change, and when they do, your application will be assessed on merit.
Okay.
So it's a case-by-case approach, and it's a circumstantial thing. So at the time of application, your circumstances are assessed based on what you have presented. So it will not be the case that they will ask you, why is it that we said no for the visit and you are now going as why didn't you go first this way? No. I choose what I want at what point. So it's not a big deal. If the person is making another application, they will assess based on that. What I will point out is that if the person making a new application, they have to be careful to repeat the relevant fact in the second application when they are asked to do so. So the first application for visit, they might have asked, do you have a family member? You say yes. You are doing application, different application, second time, they ask you, do you have a family member? And you say no. Then the conflict will be flagged. So why they change?
But don't we have the situation where each application stands on its own merit?
All right.
So why would they be cross-referencing?
Okay, so let me give you an example. What's your name, please?
Also from Paul.
Also from Paul. So you are visiting the UK, you've made application to the embassy in your country of origin. And you say, my name is also from Paul, date of birth, place of birth, everything. For whatever reason, sometime later you are making another application and they ask you, what's your name? And you say that, Wache from Paul, date of birth, blah, 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 blah. Then it comes out that the same face, the same date of birth, but new names. But then at a point they ask you, have you ever changed your name or have you ever been known by another name? On that application you are making the second time, and you say no. But the name you gave the first time is different from what you are giving the second time, and yet you haven't changed your name or you have not been known by any other name before.
Okay.
Then you are sort of misleading in a way.
In that case, they will punish you.
In that case, you are factually incorrect, whether to deceive or it might be innocent error. But if this is it, then it has to be. So in this case, if your name has changed, you have to say, yes, I was known by this, then you provide that support it with change of name. You are allowed to change your name. So those are the specific factual points that no one expects to change. But in terms of why are you visiting, this time is different. So they won't ask you, why have you changed your purpose of visit or purpose of going to the UK?
Okay. The next question I have here is, why is it that I've been asked to renew my child's passport after 3 years at the Ghana High Commission when I know that these days they issue 10-year, they issue passports for 10 years. My child is 10 years old.
Right, so we are discussing UK law. So this is a jurisdictional point. The person is making reference to provisions under Ghanaian law.
Okay.
So I will not be in haste to respond accurately. But I would just want to assume that if it's an error, you ask them. Okay. And if it's a case of change in their procedure, that this time is 3 years instead of 5 years or 10 years, then it is what it is. So what I would say is that a person should contact the Ghanaian embassy or the consulate to ask for clarification on this point.
So, please don't be sending things to my private number. People know it, and it sometimes. Somebody is asking, can you please find out why I should take a transit visa when I'm traveling on KLM and transiting for just 1.5 hours?
All right. So there's no time period or bands within which you'll be exempted from transit visa and the ones that you are required to pick transit visa. Transit means you are entering the zone for limited period, ranging from 1 second to days or weeks. You need permit to enter the zone because the flight will be entering that zone, which you don't have right to step out of the flight. And the flight, when you get there, they will say, everybody go wait. So you'll be stepping out. So you need permission to step out.
But look, I know it's not your fault, but let me just push this to you. Listen, my final destination is not Amsterdam.
Yes. So I agree with you, but the point is, if you feel that you don't want it, go direct, because there are other direct routes.
That's more expensive.
Well, it's a matter of choice. So the point I'm making is that if you are unsure, speak to the airline. But I do know that after the withdrawal agreement, Brexit and all that, lots of the airlines have reverted to the previous position where you needed transit to enter, to pass through their ports. So if you are in doubt, call the airline. If he said KLM, definitely you need it. But call KLM. If you hold British passport, then you don't need it. But if you hold any other passport, of course, it wouldn't be EU, because EU, then you don't have a problem. If you hold any other passport, then they will expect you to. But speak to them. Call KLM. Tell them that I'm traveling tomorrow. Do I need a transit visa? And if I don't have it, what can I do? They will tell you what you can do. But if you haven't bought your ticket and you think that you can't go through the stress of getting a transit visa, go direct. You can use Africa route in terms of other lines that are from other African airlines. So Kenya, Morocco, and some other countries, you don't need transit visas. But if you want to go through Schiphol and Shop and Go, then prepare to have your
I don't even want to shop. I just want to get to my destination.
Yeah, but people will go there for some reason, won't they? And if your destination is your priority, then go through other means to get to your destination.
All right. 0739920846, 020812311016. Send your text and your comments to 0795042278. I've seen one from Ademonunkum. A friend of mine wants to live in the UK. He does not have any family here. What kind of application does he need to do to live in the UK?
Okay. Right. So our friend who wants to live in the UK has to ask him, the word is live in the UK, not visit. So I think, in this case, visit is not an option. Okay. But he wants to live in the UK. Yeah. So he cannot apply to enter to visit. So that is out. He can apply to come and work for a company. So get a sponsorship from a company and come in as a sponsored worker, live and work. Or he can come in as a student, school, live and school, so to speak. Or he can come in as a spouse of somebody who is living in the UK to come and join them to live in the UK, or a dependent of somebody depending on the person's age. So those are the options. Visit is not an option.
Okay. 0739920846. Okay, Pakusi, yes, we'll be getting to you very soon. Pakusi has a question. It says, do you have your office in Accra, Ghana? If you do, please send me a contact. I need your help. So Pakusi, we'll get to you shortly. What kind of help do you need? Maybe when you get you on, you can tell us what it is, and lawyer can help you. Lawyer, I mean, call Pakusi, so I will Ghana. Now, I'll say, I need your help. Pakusi.
Yes, sir. I'm sending my WhatsApp.
What was it to say?
Yes, sir, boss. Good evening.
Good evening, Pakusi.
Yes, sir.
Boko there.
Nyame adumo me hu now say.
Nyame adum boko. Pakusi will say, please, I need your help. Mwabe na also here concerning Wakwenju.
Me ba ja say.
What's sending a text, sir? Please, I need your help. I want to find out, sir, what help do you need?
Yeah, so your friend is saying, what do you call it? Many of you, our na opese obefami or next week.
Oh, yeah, then we're nurse.
Nurse, or yeah, or mental side, mental health side.
So we're here nurse with UK, okay?
Yes.
Okay.
Yes.
Okay.
But previously, the number application is better. I know many will be but if you see it. But that is 2 years ago.
What worry will be 2 years ago? And an Ipania said, oh, no, refuse here. Nipakor, when in a Jaya warrior. When in a Jaya warrior.
Divorce, married divorce, I be.
Okay. And now, to say, we are away on the nest, no person de oba. And then also here one.
Yes. My patron.
What ben are we here?
So, I was application will be kind of nim deal. And now, my me here making the application at this time, I will not be refused. And then I'm here. Now, my particular, the main problem is because of my previous issue, and I don't want to, like, Your friend is saying.
So open lawyer
Me
man
person
I
many
am o.
problem
And I say
biya.
open lawyer, open
Aha,
say.
many lawyer no I am yes.
Open lawyer man I am o.
Mpacho.
Yo. And yeah, your office was Ghana. Until now when say offer
Mpacho.
office no a. Oma arrange consultation ama o. Na one lawyer snack back
Okay.
makasa. Na afutu e ho no ye
Okay.
dama o. But na ewo mu ni
Okay.
nyina ne say the way be say you refuse to pay na obeka no correct say yes, you refuse to pay. Na
Okay.
what kind of cry no case worker no be make a decision based on new application no a wo ye no. Nti ebe hia say obeka no
Oh,
cry ewo mu ni na why?
no problem. No problem.
Okay, nti we sabeka number na wa frɛ na we buku na we call your Ghana office no. Why?
Okay. Okay, sir.
Okay.
Okay. Thank you so
Sir,
much.
baby, I would you know wait me at your Ghana number no.
Baby, I'm just making your Ghana number now.
Okay. Yeah, 050
050
462
462
2794.
462
2794.
2794.
Yeah.
050 462 2792.
794.
794. Okay.
Yeah. Okay. How is he? Yeah, that's it. Why?
Yes, sir. Mr.
Into
Medasi,
offer
sir.
Mbabwa. Why?
I will let you know.
Me patch you. Yeah, that's it. 073-992-08468. Hello.
Hello, BWF.
Yes, sir.
Anyway, but your friend me, Maxwell, my friend Birmingham.
Maxwell, yes, patch you too. That's it. Very well. Thank you very much.
Where did you be? Oh, yeah. I said, me, I'm a kind of the mood that BWF, one of my minimum of money, my partner, one of my rated. I urge people to be avoiding the consultancy and that bit of BF now.
That's right. Thank you very much.
Anyway, number two, me bisa say, me EU family, this year, menya indefinite, settled. I thought, I didn't hear with my partner no one, I'm a application.
Yo, live.
Yeah, it's live. Yeah.
So, our brother, Opechi and English. Okay. So then, for the benefit of others who are interested in your question, so you want to,
that's good.
You want to finish your route, literally. So you've done a pre-settled, and you are going to settle. Is that the case?
Yes, that's the case.
When you were doing the pre-settle, did you have to show that you depend or you are living with your family member? Was it your wife?
Yes, I had to because I had to take.
So nothing has changed.
You know that long.
Nothing has changed. You still have to.
Okay.
Nothing has changed.
So,
you still have to, unless. Are you still together, or there has been divorce?
No, we are still together, but there's been a lot of friction in the relationship. So I'm just trying to find out if in case it goes this way, in case of separation, what do I need? In case of we are together, what do I need? I just want to have a balanced advice or a balanced counsel.
Right. So if the marriage has not ended, you have to show that you are with your partner and your partner is still supporting your application. If the marriage has ended, you make an application under the retention provision to show that the marriage is no longer there and therefore you want to rely on your previous right when you were doing your pre-settled application.
Okay. I understand. So if what do I need from my partner?
Everything that you needed before.
Okay, including the marriage cert and other documents.
Everything that you used before.
Everything I used before. Okay, that's clear for me. And on the other side, marriage doesn't stand again. I need to
your line
is a bit patchy.
right?
What's it?
Yeah, sorry, sir. I mean, on the other hand of the argument, if the relationship doesn't exist again, I need to present a divorce certificate, right?
Yes.
Okay.
Okay.
All right. It's clear. It's clear to me, sir. Thank you very much. God bless.
Thank you very much. 073992084680 0795042278. That's for our text message. And very soon I'll be introducing my right-hand woman, Nama Yete, to join us. I think there are a few questions there that we would have to pick from her side. Hello.
Yeah, hello.
Good evening.
Good evening.
It is a boss.
Please, am I speaking to BW?
Yeah, you are live on BW TV.
Okay.
Can you
I
put
have a
off the
problem.
volume of your computer or TV so we can speak to you on the phone instead?
Okay. Okay. Hello.
Yes, sir.
Yeah, my name is Godfred.
Yes, Goddy.
Yeah. I have a bit of problem.
No problem. We're here to support you.
A friend of mine is in the UK now, and then he has overstayed his visa.
Okay.
So now we got a lawyer, and the lawyer wanted to help us through this way.
Which way?
The lawyer is saying that he wants to file an application for us.
Okay.
As in through this gay, because Ghana does not accept gay.
Okay.
So he wants to help us through that side. Now, it is two things. One, he wants to file the application through the Home Office by doing the gay first, and then after that, the second way will be he will seek an asylum for this my friend. Now, I wanted to know if is there any true process like that?
Are you speaking from Ghana?
No, I'm here. I'm here in the UK.
Okay, so are you asking for somebody?
Friend.
Okay, all right, lawyer. Let's see what.
Okay. How are you, our brother?
I'm fine.
Good. So your friend feels that he cannot go back to his country for fear of persecution because he believes in some aspect of ideology, different ideology. He is gay, and therefore, when he goes back to his country, he will be persecuted because his country does not believe in that. Now, your friend wants to seek asylum. I think that's what you have said.
Yeah.
So the laws in the UK allows for people in that difficult situation to retain or to remain in the UK rather than being asked to go back to their country if there is risk to their lives.
Okay.
So that is the asylum provision or process. But his reason is what you have indicated.
Okay. Okay. But I want to know what are the chances of
That application going through successfully?
Yeah.
Right. Did you say that you have spoken to a lawyer who is assisting with that?
We've spoken to a lawyer, but we've not concluded. So I wanted to know if that thing is still working.
Have you had a consultation with the lawyer?
Yes, we've had a consultation with the lawyer.
And obviously, the lawyer would have told you that this is one of the options, as you have indicated. And I'm sure the lawyer would have also told you
Exactly.
what the chances are, because that's the reason for the consultation.
Yeah, yeah.
So if the lawyer has given you your chances, then that is what it is, okay?
Okay, thank you.
Thank you.
All right, thank you as well. 07399208468, text 0795042270. And this is the point where I introduce my right-hand woman. I was going to say partner in something, but no, we're not doing that here.
Partner in everything beautiful.
Everything beautiful. Thank you very much. That's why I have a lawyer friend, you know.
Good afternoon or good evening, Oreku. And
Good evening.
Good evening.
It's been a long time I've been on this platform.
Yeah, I know. Where have you been?
Oh, Oreku, it's just been here and there, everywhere. I don't know which one to confess, but I've been everywhere. Anyway,
and how's KT Educational Consult doing?
Oh, God has been faithful. In fact, we are growing, and thank God. In fact, we are growing. It's been good. It's been good. Let me just put it that way. Yes.
I need to come and write my name down and do my English lessons.
You are welcome. We are actually extending, because we've actually engaged some of these teachers. The new teachers.
Hello.
Now, let me just take the wind out of your sail for just a moment. Pick up this call and I'll come back to you in a minute. Hello.
Yeah, hello.
Yes, sir. Good evening.
Good evening.
Good evening.
Please, can I speak on the show?
Yes, sure. Let's hear you.
Okay, please. I'm an overstayer. I want an advice how I can be able to get my papers if it's possible.
Now, before I hand you over to the lawyer, you say you're an overstayer. You came on what condition? Were you a visitor? Did you come
on a visit
a
visa.
different route or something? Yeah.
Yeah, I came on a visit visa, a 6-month visit visa.
Okay. How long ago was that?
Yeah.
How long ago was that?
About a year or two.
Okay.
About
So
a year. Yeah.
You were stayed for about a year.
Yes, please.
Okay, lawyer.
Right. How are you, our brother?
I'm doing very good.
Good. Right. So you have overstayed and you want to know your chances of remaining. Now, I'll give you scenarios, and each scenario will present an option, and each option is for you to consider.
Okay.
So one scenario will be, for example, that you have overstayed because it is difficult to return to your country and your village or community for fear of persecution. If that is the case, then you make an application to the authorities in the UK for consideration. That is called asylum. The second scenario will be that having arrived in the UK, lived your life in the UK, engaged in activities in the UK, and formed relationships in the UK, you have been blessed with a child in the UK. That child is a British citizen or EU citizen. In this case, you help with the care of your child. In that case, you can consider making an application under the direct access provision, even if you do not live with the child and the mother. In this case, you seek permission to stay so that you can be part of the child's life. In this case, because of the child, the application will be considered in your favor. so that he can be here to help with the child. But you have to prove that you have a child and your name is on the child's birth certificate. The other scenario will be that whilst living your life in the UK, having overstayed for about 1 year, you have a wife. However, you have married, I don't know which country, but you have married and your country allows for proxy marriages, which UK also accepts. In this case, you can make an application that because of specific circumstances of your wife, you should be allowed to stay in the UK. For example, if your wife is disabled or going through some health complications and you are the only person supporting her care, in that case, physical care, then it makes sense for you to be considered to be around so that in the interest of your wife, even though she's not a child, then on that basis. Otherwise, they usually will say that you are both healthy, you are both strong, and therefore you can both have your marriage life outside the UK. That would be the downside of the application. The other circumstance or scenario will be that whilst living your life in the UK, you form a relationship with a woman. The woman already has a child. The child is British or has even 2.5. On that basis, the woman is your wife and you have become a stepfather to this child. And on the basis of your stepfather relationship with the child, you make an application for you to be considered so that the family unity can be protected, so that you are not separated from being part of the life of the child, especially, and of course, the mother. Because you are in the life of the child, you support the mother to care for the child. And even though you don't work, you possibly take care of the child while the mother is working. And that is helping to develop the child and to help the child. And on that basis, you make the application as a stepfather to that British child or EU child. These are your scenarios, and I'm sure your options are clearer.
Okay, thank you very much.
The last
for the
one
information.
will be,
Thank you.
The last one will be
don't go yet.
The extreme one, which,
All right.
of course, you can consider. If you are living in the UK already and you continue to live for 20 years, if the law has not changed by then, you can apply under the long residence
That's a
provision.
long route.
Of course, that is the long.
That's so long.
Extreme option, but of course, suffice to say that because I'm giving you options, this is one of the options.
All right. Thank you very much for the
You're
information.
welcome, boss.
Thank you.
All right. Enjoy your evening. Thank you for joining us on the program. Okay, let me go back to now. I took the wind out of your sail. Let me bring it back and get us going. I know you may have some questions that you would want to write to the lawyer.
Yeah, thank you. Sir Charles, I've got 2 questions. I know the time is already almost up, so I'm going to be quick. First of all, this person sent this message to me saying he's got an indefinite before applying for British citizen, obviously, yes. But now he has changed his mind and want to renounce his citizenship. Will he still get his indefinite back, and if he does, is there going to be any consequences by renewing or renouncing the British citizenship? That's the first question.
But well, if he's got citizenship, then we don't talk about indefinite.
Yeah, he had before, and then he applied to become a British citizen.
So
now
the
he
point,
doesn't become a British citizen anymore.
Yeah, the point I'm making is that once he's British citizen, we do not discuss indefinite leave to remain status.
Oh.
So for him to say, will I have my indefinite back? I want to believe that will I have my citizenship back after I have renounced it? Maybe that's what he meant. Because if you have citizenship, once you naturalize, we don't talk about indefinite. Okay. Because you are a citizen. Indefinite is for those who still hold foreign passport as their main passport or country, but they have domicility or they remain in the UK indefinitely, but they are not British citizens.
Yes.
But once you become a British citizen, we don't talk about that. That's why when you become a British citizen, they tell you bring your indefinite card.
Oh.
So he's a British citizen. Can he give up his citizenship and go back to original citizenship? Yes. Can he come back later if he changes his mind again? The law allows for, I have to double check the number of times, but at least he can have it once to come back to.
Okay.
But he has to go through the process
right
to apply for renunciation.
So after renouncing that, what is it? That means he's no more. He hasn't even got any state to live in the country, or he has to go back to his own country.
Okay, so what he's saying is that he doesn't want to be a British citizen again.
Exactly.
So he wants to go back to, or he wants to assume his original status.
Yes.
Now, what happens is that because he already has right of abode, that is why he can change his mind and come back to it again.
Okay.
So you give it away, have it back again, but for a very limited period or times.
I see. Okay.
So it's a decision that a person need to think through properly, consider why, in terms of pros and cons, and if it is necessary for him to do so, he goes ahead to do it, because the implications are there. But if the benefit of doing so outweighs the implications, then why not?
I'm sure he knows what he's doing, because the aftermath conversation that we had was he wanted to go and live in Ghana forever, and he wants to claim he's something. I don't know if it's insurance, whatever, but if he's a British citizen, it will not allow him to claim those things. So he wants to renounce.
Well, I believe he's considered his options and he's clearer on the decision.
Okay, then. All right. Thank you. Now, let me go on to the other question. He said, yes. Where do I say this English? Okay. My question is, if someone British British citizen is stripped off, will he ever be able to apply again or not?
Right. So once your citizenship is taken away for whatever reason, of course, we've talked about basis for that under the new provision and also the existing provision of the laws. If you lose your citizenship, you go back to square one, so to speak. If for whatever reason you are sent away from the UK, then you have to come back through application or an entry clearance process. And if you are barred from entering, then that will take longer. If you are already in the UK and you are lucky not to have been removed after your citizenship has been taken away for whatever reason, then you have to start the process again.
All over again.
It might be that the person would have lived in the UK for 20 years, so they will go through 2.5 process under the long route, 20 years route, or any other means they may have at their disposal. They will explore that, but they have to start the process again.
Right. Wow. Okay. I think that's just the two questions I've got. So, Oreku, let me throw it back to you, and you can continue from there, please.
Thank you very much now for the intervention and very timely questions. And on that note, we're going to do our quiz and test our knowledge. But before I do that, let me go back to the nugget that we used for our discussion earlier on. Now, it says as all landlords in England are required by law to conduct a right to rent check before renting property to a prospective adult tenant. Right to rent check only applies to privately rented accommodation. Now, if a landlord is found to be renting to someone who does not have a right to rent, they may be liable for a civil penalty of up to £3,000 per tenant. If they do so knowingly, they may also be committing a criminal offense. And it says that according to the Immigration Act of 2014, everyone who has lawful permission to stay in the UK has a right to rent residential accommodation as their only or main home, or even if it is for a limited period. So now my question comes in. There is this our friend, Lady Liz. Now, Liz applies to as a tenant in Abacus House, a privately rented accommodation. At the beginning of the process, Liz told the agent that she holds 2.5 years as a parent and presented her biometric card as a proof. The agency told her that as her visa is time restricted, she cannot rent property and refused the application. Liz wants to make a complaint to bring an action against the agent. Now, what can Liz reasonably rely on as her reasons for the complaint? 1, she has been discriminated against because she's a woman. Where did that come from? Her time has been wasted by the agent. And 3, she has a potential claim under the Equality Act of 2010 for discrimination. Now, before I ask you to do or send in your thing, I'm going to read the nugget again. And if I had a chance, I would have referred you to the explanation lawyer gave for anybody to have the chance and the authority and the permission to rent property. Everyone who has a lawful permission to stay in the UK has a right to rent residential accommodation as their only or main home, even if it is a limited leave to remain. Now back to the question. What the three options we have, what can Liz reasonably rely on as her reasons for the complaint? She goes to this agency to rent privately and presents her 2.5 years as a parent, which I know is a limited leave to remain. Presented the biometric card as a proof. The agent tells her that the visa is time restricted, so she cannot rent property, and the application was refused. Liz said, no, I won't understand. I won't agree. I am going to bring a complaint against you. So what will be the reason or the basis for her complaint? She's been discriminated against because she's a woman. Her time has been wasted by the agent, or she has a potential claim under the Equality Act of 2010 for discrimination. Now drop your answers. So wait. Now, are you there? Okay. If nice, I was going to ask her to give us what's happening on the front of the teachers and what KT Education is doing as we wait for some answers to come through. Your text I can pick on 0795042278. Rajwa, you're watching. Emmanuel Nekwe, you're watching. Naomi Bua, you're watching. Thank you very much. Emmanuel Nekwe, yes, I've mentioned your name. Lily Sowa, and all the other bits. So all the other people, so to speak. So yeah, let's see what answers are we having. 0795042278, or you can put it on the platform either on Facebook, YouTube, LinkedIn. Ademunukun says number 2. Her time has been wasted. That's an interesting answer. Time has been wasted by that. Yeah. Okay. Kojo 24, you say you're watching. Kojo, what's your answer? Is it 1? Is it 2? Or is it 3? Anyway, we're running out of time, so I will quickly come back to you. Laura, this is a situation where this lady thinks that she is being discriminated against. She has presented 2.5 year biometric card to this agent. Let's see what answer somebody else has. So before okay, Bless Sin is number 3. She has a potential claim under the Equality Act of 2010 for discrimination. Okay. Laura, is this an act of discrimination? Okay. Amma Diana says number 3. Okay. Kwajo 24 says number 3. Okay, Kwajo, you've repeated your answer. I've seen it 3 times. Thank you very much. Laura, what could be the most viable basis for the complaint that Liz is bringing against the agent?
Right. So the key thing is what the law says, that anyone who has lawful residence in the UK can rent.
Okay.
So that's the starting point.
Okay.
Everybody, including Liz. Now, to bring claim on or for discrimination, you have to show that one, there has been a comparator and that comparator has been disadvantaged in a way.
Okay.
So what is a comparator? Liz is one person comparing Liz to anyone with lawful residence in the UK. So will everybody be told that they cannot rent?
Mm-hmm.
So if anybody else came with 2.5, would they be told that they cannot rent? Or has that private agent always given opportunity to those who have settled status or citizenship?
Mm-hmm.
If no, then Liz should have been considered like anybody else who had 2.5 and was considered. So Liz has to show that there's comparator, and we can establish that there's comparator. Comparator is that she is lawfully resident in the UK. She has 2.5, and it doesn't really matter whether you have 2.5 citizenship or settled status, and therefore you are all the same.
Mm-hmm.
And if the private tenant gives to people, he should also consider Liz, because Liz is on the same level with those people who have leave to remain or residence lawfully in the UK. Now, we are not touching any of the protected characteristics, because the facts pattern does not make reference to any protected characteristic. In that, the fact pattern didn't say that the agent said because you are a woman, because you are black or white or green or blue, because you are this, because you are that, because of your sexual orientation, because of your religious orientation, because of this or because of that. It does not make reference to any of the 9 protected characteristics.
Okay.
What the agent says is that because you do not have indefinite or citizenship,
okay,
because you have limited. So the question is, does this agent only give to those who have the indefinite and citizenship? Has the agent ever given to somebody with limited leave?
Okay.
If the agent has ever given to somebody with limited leave, like Liz, then on this occasion, the agent is disadvantaging Liz.
Mm-hmm.
And therefore, Liz comparator will be everyone who has lawful residence.
Okay.
And because she has lawful residence, she's being discriminated against in a way. So it's not a case of a protected characteristic. So you can see that this is not an obvious aspect of the equality provision in terms of protected characteristic. But again, if you look at it carefully, you can see that the person has discriminated or has been unfavorable to somebody. And therefore, we have the comparator, or the people who have lawful residence. We have Liz, who qualifies and has been disadvantaged. And I like the way the point is set out, potential claim.
Mm-hmm.
The point didn't say claim.
Claim.
Potential claim.
Okay.
And the potential claim is that even though we are not touching any of the protected characteristics, we are touching on aspect which is comparative. And therefore, Liz can bring a potential claim that she, being someone lawfully resident in the UK, should have been given opportunity like anybody else.
Okay. So the answer will be number 3. Numero 3. She has a potential claim. I think lawyer rightfully put that in the answer for you. She has a potential claim under the Equality Act of 2010 for discrimination. But as Nugget really pointed out, it says that any person that has limited leave or any rightful permission to live in the country can rent. The last paragraph of that one says everyone who has lawful permission to stay in the UK has a right to rent residential accommodation as their only or main home, or even if it is for a limited period. Lawyer, Bernard Fosu, you're watching, but I didn't tell me what your answer is. Amadina says it's number 3. Ade Mununkum, number 2. Well, you got it wrong. Can we just conclude that we say our thank yous? But first of all, let me say thank you to you for your time, for the right exposition, and also picking up all the questions and concerns for our various and lovely listeners and viewers. What would you say before we draw the curtains down there?
So we conclude that, yes, you can make an application for pre-settled status having been given 6 months from abroad and entered the UK and intending to make an application to stay on the EU settlement scheme. You can, even if your parents have separated. We have concluded that it is easier if the separation has led to divorce, and therefore you can rely on your retention of right to make an application to remain in the UK. However, if there's no divorce, then you have to still indicate that you are continuously dependent on that family member who brought you to the UK by way of sponsoring you under the provisions of the EU settlement scheme. So it's a case of what you wish to use, either retention of right provision or the normal provision wherein you have to prove that there is dependency. Oftentimes, it becomes contentious where you cannot prove that the other family member who sponsored you is still available to support you, and therefore it gives upper hand to the caseworker or the Secretary of State. But either way, you can make your application. It can be complicated where there is separation. However, it's a matter of legal argument. If you can, you show that there is divorce already in force by way of proceedings, or there is divorce already obtained by way of decree absolute.
Well, it's been a wonderful 2-hour period for us here on the show. Now, before we go, a quick one on the, I understand, Katie, you had a seminar for the teachers and them coming through. What should we expect next from Katie Education Consult as far as that and the English language is concerned?
Yes, there's going to be another webinar actually on 3rd, I think on the 13th, next coming Friday. We are trying to link schools with the teachers. So before you can apply to become a teacher in the UK, there are a few proceedings that you have to go through. And that is where we come in. We take you through these proceedings, the steps, necessary steps by step, one-to-one interview and things like that. Anything at all that will get you the school or that will take you through the interview process before you get the school. That's what Katie is trying to do at the moment. So if you're interested and you want to come and teach in the UK, just contact us on our email. Just send an email or the WhatsApp number, send hi or just show your interest, and then we'll get back to you ASAP. So that's what we are doing at the moment.
Well, and on that note, I want to say thank you very much for sitting in for me last week when I had to go underground to have some rest. I've seen all the good wishes, the birthday messages, and the rest of it. I so appreciate everybody. Thank you so much for wishing me well, and we're going to go through another solid year together again. So be prepared to be with us every Saturday afternoon between 4 and 6 on the community and the law. So on behalf of everybody, thank you very much. And let me also say that thank you for joining us to Padmo Dudu, Sheila Ankra, and all the members of BWF Solicitors, are two wonderful ladies who were voted jointly as the employees of the month of February. Congratulations to you, more grace to your elbows. And to my dear friend and brother, lawyer Charles Asma, for helping to answer all our questions, and graciously, I know he's agreeing to come again next week. And then to my lovely Na Mayete, thank you so very much for your support and everything. Our viewers and our listeners love you to bits. In fact, when you are not on, the text messages I'm getting far too many asking, where is beautiful Na Mayete and all that. She's right there. She's always available to support you. And to my producer and director, Professor Ade, thank you for your time and, of course, your direction. My name is Oreku Fripon, and I want to say I'm drawing the curtains now. I'll be back again same time next week. Until then, be good.
everything, yeah. My everything is you, Lord. Yeah. Ha-ha. Oh, 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 oh. Everybody say, ah. Say, how can I express my gratitude for all the many things you've done for me? Words